The Epstein files are a large and complex set of government records. They come from federal investigations into the financier Jeffrey Epstein. Epstein was charged with serious sex crimes involving underage girls. He died in a New York jail cell in 2019 while awaiting trial. A death ruled a suicide. For years, various U.S. government agencies, including the Department of Justice and the FBI, have collected and stored millions of pages of documents related to his cases. These records form the collection now widely known as the Epstein files, a vast archive that holds details about his criminal network and how law enforcement handled the investigations over many years. Instead, they are a sprawling collection of different types of materials gathered over decades. Epstein's initial non-prosecution agreement in Florida, his later arrest and charges in New York, the case against his associate, Ghislaine Maxwell. Because the files span such a long period and involve multiple jurisdictions, they are incredibly dense and voluminous. The public has long demanded access to these records, believing they hold the key to understanding the full scope of Epstein's crimes, the powerful individuals who may have been involved or who helped protect him from justice for so long. The push for the release of these documents has been a long and difficult battle. Victims, journalists, and lawmakers have argued that transparency is essential for accountability. They believe that making these records public is a necessary step toward understanding how the justice system failed Epstein's victims. The story of the Epstein files is therefore not just about one man's crimes. It is also about the public's right to know and the government's obligation to be transparent about its actions, especially in cases that have shaken public trust in its institutions and powerful figures across society. Today, as of early 2026, a significant portion of these files has been released, but the process is far from complete. Understanding what is in these files, what has been released, and what remains hidden is crucial for anyone following this story. The process involves legal mandates, immense logistical challenges for government reviewers, and ongoing debates about privacy and public interest. After years of public pressure and advocacy from victims, the U.S. Congress took a decisive step toward forcing the release of the Epstein records. In late 2025, lawmakers passed a landmark piece of legislation called the Epstein Files Transparency Act. This law was a direct response to criticism that the Department of Justice had been too slow and secretive. The bill received overwhelming bipartisan support, passing the House with a near-unanimous vote of 427-1 on November 18, 2025. It was quickly signed into law by then-President Trump on November 19, 2025, marking a major victory for transparency advocates. The Epstein Files Transparency Act created a clear legal requirement for the government. It mandates that the Department of Justice must release to the public all of its unclassified records related to the investigations of Jeffrey Epstein. This includes files from the FBI federal prosecutors' offices and other DOJ components. In accordance with the new law, the Department of Justice began releasing the Epstein files to the public. The first release occurred on December 19, 2025, the deadline under the Epstein Files Transparency Act. The initial batch was heavily redacted. It met the deadline, but the release was small and left many observers wanting more. Seen as a preliminary step, it showed DOJ's intent to comply while exposing the huge task of reviewing and redacting millions of sensitive pages. Just over a month later, on January 30, 2026, the DOJ announced a massive publication. The department said it had published over 3 million additional pages. It contained more than 2,000 videos and about 180,000 images, collected as evidence. That volume offered a much deeper public view of the case. The January release brought the public total to nearly 3.5 million pages. DOJ stressed the enormous effort behind it. More than 500 attorneys and professional reviewers were assigned to the project. Their work: go through each document, identify sensitive information to redact, and prepare files for release. This logistical challenge explains the slow pace and the limited December release. Still, the process wasn't finished. DOJ acknowledged millions of documents remained under review and unavailable to the public. Before the large release, DOJ told a federal judge less than 1% had been made public. Even after the 3.5 M pages, a significant portion of the archive stayed out of view, awaiting review and redaction. Even with millions of pages released, a large portion of the Epstein files remains hidden from public view, either through redaction or by being withheld entirely. Redaction is the process of blacking out specific pieces of information within a document before it is released. In the context of the Epstein files, the 2025 Transparency Act permits redactions primarily to protect the privacy of victims. This means names, addresses, contact information, other identifying details related to survivors of Epstein's abuse are supposed to be removed. This is a critical protection intended to prevent re-traumatization and respect the wishes of those who do not want their identities made public. However, the application of these redactions has been a source of major controversy. In many of the released documents, entire pages or large sections of text are covered in black bars, making it impossible to understand their context or meaning. Lawmakers and critics have referred to this as a blanket approach to redactions. Beyond redactions, the DOJ has also withheld millions of documents entirely. The release of the Epstein files, while intended to promote transparency, has drawn sharp criticism, most notably from survivors of Epstein's abuse. While the law was meant to protect identities, advocates say the redaction process was flawed and in some cases caused more harm. After the January 2026 release, survivors issued a public statement criticizing the DOJ. This latest release is being sold as transparency, but what it actually does is expose survivors. They said victim names and identifying info were exposed, while powerful men who abused them remained protected by redactions. That criticism was backed by evidence in the released documents. As the Department of Justice releases millions of pages, the sheer volume can be overwhelming for the public to navigate. The government's official portals for these documents are often basic, making it difficult for an average person to search for specific names, dates, topics. In response to this challenge, independent organizations, journalists, volunteer groups have stepped in to create their own archives. These projects download the officially released files and build more sophisticated, user-friendly platforms to house them. They index the documents, use technology to make the text searchable, allowing a user to type a name or keyword and find every occurrence. Some archives create detailed indexes of key info like flight logs from Epstein's private jets. When people talk about a full release of the Epstein files, they mean a specific and comprehensive vision of transparency. In practice, this would mean every single unclassified document related to the Epstein investigations held by the Department of Justice, other federal agencies made available to the public. This goes beyond the nearly 3.5 million pages already released and includes the millions the DOJ says are still under review or being withheld for various reasons. A full release would leave no stone unturned in the public record. The ongoing release of the Epstein files represents a critical moment in the pursuit of public accountability. Full transparency in this case matters. First, it is essential for holding government institutions to account. Department of Justice (FBI) handled the Epstein investigations over many years, including the decisions that led to the controversial 2008 non-prosecution agreement. A complete public record allows citizens to judge for themselves whether justice was served or whether powerful individuals were protected. It is a necessary check on the power of the state. For readers who wish to view the documents for themselves, the most reliable source is the official website of the Department of Justice, where the files are posted as they are released. Additionally, several reputable independent archives have created searchable databases of the released materials. The challenge lies in balancing the public's right to know with the moral and legal obligation to protect survivors. The criticisms surrounding recent releases show how difficult this balance is, but it remains the guiding principle of this entire effort. These independent efforts supplement, rather than replace, official government releases, playing a vital role in the ecosystem of public information. The work is not complete until the records are both open and safe. As more files become public in the coming months and years, continued scrutiny from the press and the public will be essential to ensure the promise of the Epstein Files Transparency Act is fully realized, and that the light of truth finally reaches all the dark corners of this case.